Hello everyone, my name is Ajhar Rahman Kazeinda, and today I will explain you guys about Australian legal system. So, all legal systems in every country are different, and Australia is no exception. Due to Australia's federal structure, a US-style constitutional framework and English common law were combined to create this system. The legislature, which in Australia consists of the state, territory, and federal parliaments, debates and passes new legislation, just like in most other nations. The public service or executive branch makes sure that new laws are implemented. The executive branch judiciary reads the law, determines if someone has broken it, and determines the appropriate punishments. Without laws, people could do pretty much anything they please. And actually, it would most likely imply that while the weaker and poorer members of society would not be able to do as much as the wealthy and more powerful members of society. Naturally, this doesn't occur. In order to function and in order powerful, properly and reasonably equitably manner, society creates laws and regulations that serve the common good, even though some individuals disagree with the laws. A democracy always allows for the possibility of changing them if enough people support a party that does. Indigenous people live in Australia for at least 50,000 years. Indigenous people created their own laws and regulations that set forth expectations and for behavior, and provided consequences for violators. Europeans believed that Australia was uninhabited or terra nullius when they first arrived. Native American customs were completely disregarded throughout the first 2 centuries of European colonization. Tasmania and New South Wales were the first colonies. South Australia and Western Australia were later established independently. Originally, Queensland was seen as a part of New South Wales. It created a distinctly British legal system. Following attaining independence from Britain, Australia established a federation and laid the groundwork for the Australian Constitution. In Australia, there are 2 primary categories of laws: uncodified case laws that are interpreted by judges in the legal system and statutes, or codified laws that are decided by state and federal parliaments. Following a debate in Parliament that statutes are enacted, only Parliament has the authority to alter them. Although case law has evolved and changed over time, it is primarily derived from English common law. Although rules may vary from one state to another, case law generally follows a similar pattern across all jurisdictions. There are 4 main principles observed in the Australian legal system. There are equality before the law, fairness, the right to be represented, and transparency. The foundational law of contemporary Australia is the Constitution, which was ratified in 1900 and went into force on January 1st, 1901. Which powers belong to the Commonwealth are specified in the Constitution. Interstate and international trade, taxes, telephony, and related services such as television, defense, some fisheries, currency, banking, corporations, marriage, social service, minority racial groups, migration, and foreign affairs are all examples of Commonwealth powers. A power is a state power if it is not identified as a Commonwealth power. The nature of the power and the Commonwealth Parliament's authority to enact specific legislation are occasionally questioned. For instance, what does marriage entail? By interpreting the meaning of the Constitution and the contentious law, the High Court provides answers to these queries. The statute is void if the High Court determines that the Commonwealth Parliament lacked the authority to enact it. Since 1900, the meanings of the phrases in the Constitution have evolved. This implies that the High Court's constitutional interpretation may change over time. For instance, Section 51 Race Power Clause, which formerly defended racist laws, is now a provision that forbids them. Australia is a nation with common law. This implies that judges and magistrates must bear their conclusion in court on previous rulings in situations that are comparable to their own. The foundation of the common law system is the principle which is known as the doctrine of precedent, which translates to stand by that decided. The doctrines of precedent provides an important constraint or judicial decision making. The general idea behind the doctrine of precedent is that judges, when they are deciding cases, must pay proper respect to past judicial decisions and make consistent decisions. If the facts of a case are unique, judges may be required to make more innovative decisions. These cases create new legal precedents. Dunov v. Stevenson is one well-known example of a procedure case. A judge must declare that they are not following precedent and provide an explanation if their ruling conflicts with accepted precedents. Although they are required to follow common law precedent, lower court justice may express unhappiness with it. So that's all about the explanation of Australian legal system. That's all from me, and thank you for your attention. Goodbye.